Law School and a faculty co-director of the Berkman Klein Center for Internet and Society. And finally, we have Professor Graham Didwoody. He's a university distinguished professor and the global professor of intellectual property law at the Chicago-Kent College of Law, where he also serves as co-director of the program in intellectual property law. As in the prior panel, we're going to start by giving everyone 10 minutes to give remarks on their chosen topics. We'll probably then come back and do a second round of responses, reflections, questions, and then we'll finish up with an opportunity for folks from the audience to ask questions. Before we jump right in, I do want to pause a moment and say that this panel is a little bit different from what we normally see at academic conferences. I think as legal scholars and as lawyers, we're predisposed to look for problems, right? We're predisposed to look for what went wrong, to explain why it went wrong, and maybe to try to look for solutions to those problems. So we spend most of our time as academics thinking about the many ways that Congress and the courts could have done a better job. And today our task is to do the opposite, sort of to go against the grain, to go against our natural urge to criticize, and instead to identify areas where maybe as much as it might pain us to admit it, policymakers seem to have actually gotten it right. So bear with us as we try our best to ignore sort of decades of daily conditioning and just try to give credit where credit is due. If we can't pull that off, this will be the shortest panel in the history of academic conferences, so we'll see how it goes. Okay, first up, we will hear from Professor Palmer.
Thanks so much. So yes, I think that has encapsulated exactly the challenge of this panel. So yes, I am going to try to focus on what we're right, but there will probably be some leakages of critique mixed in with that, and apologies in advance for that. So I'm going to be talking about trademark law and the Lanham Act and the changes it's wrought over time. And I'm going to focus on a few different things. I'm going to focus on how it really entrenched a system of nationwide registration, how it's put into place a pretty robust system of trademark examination, and at the same time, the dual protection that it offers to unregistered marks and registered marks, and how it has systematized distinctiveness through the case law in particular ways, as well as give us a vantage point of musical perception. Those are 5 different points I'm going to walk through. And so first I want to talk about establishing a system of nationwide registration. I think you heard from Professor Farley a little bit earlier that yes, we had registration start to come into place before the Lanham Act, but the Lanham Act is really what, I won't say established it, but really entrenched it. And this is a big deal because it made locating other businesses' trademarks much easier, and this can be understated. Before that, in the history that we see people designing marks to avoid getting hit with trademark infringement or a form of something like trademark infringement because they didn't want to be found to have accidentally infringed. So in the logo context, we had much more complex logos, very intricate designs, and one reason that is offered for that is businesses didn't want to get hit with accidental infringement. If you design something simple, that could happen. So once you have a system in place where you can locate other people's trademarks more easily, you're going to be able to avoid that and maybe create more optimal and choose more optimal marks. Over time, this has been very successful. We see, at least in terms of numbers, we see over 500,000 applications per year and growing. We see this broken down across different classes of goods and services. And we have an examiner corps, professional examiner corps, similar in certain ways and different in other ways than what we heard on the patent side of the past panel, to examine trademark applications. I will say that, I'll talk more about that in a bit, But they developed this intricate system to actually be able to help people locate marks. Some of this was done to help the examiners locate marks as they were searching through things. But then the public has gotten much of the benefit of this. So on the word mark side, words tend to make up most trademark applications and registrations. There are ways to search phonetically. That's been in place for quite a long time, even before we've gotten search tools on steroids available publicly in recent years. And in future work that I'm doing with Martin Beebe and David Stein, I do take the Trademark Office to task for the way that it examines images in trademark law. But at the same time, I want to give credit where it's due. Before it was as easy as it is now to search through images, they put in place it's Borgesian, but they put in place a design search code taxonomy to try to categorize every image that there might possibly be, whether it's women from Scandinavia to power tools, and to make it easier to search across them. So I think there was just a lot of thought and care that went into this, both for the examiner's sake and then the public got some of that benefit. I also think it really helped, among other factors occurring in the United States, to enable nationwide commerce. Because now you can see what businesses are doing in places that you're not in, if they're in the registration system. I don't know that anyone would have expected it to get to the state of development that it would have gotten to. Barton Beebe and I have explored this in previous work. 3/4 of the time you're speaking, you're using a registered trademark, and most of the 10,000 most frequently used words in the English language, which is most of the language, are claimed as trademarks. But it might have accelerated. I just want to say trademark depletion and congestion, but it also put in place the ability to develop commerce in a smoother, easier way. So let me just spend a minute or two talking about trademark examination, and I want to contrast what the United States did with what the European Union has done. The United States Trademark Examiner Corps, they will not only examine whether a mark is distinctive in order to get registered, but they'll also examine whether it's confusingly similar to existing marks. The EU has chosen not to do that. I always find this funny because when we stereotype the United States, we think about free markets here, and the EU, we think about paternalism, but they actually have exactly reverse roles. The EU says, we'll stay out of it unless a business complains. In the United States, the trademark examiners say, we're not letting you get this registered because we've decided it's confusingly similar. And so, I've critiqued in a lot of my scholarship how robust trademark examination is, but I think it's important to remember it's generally doing a pretty decent job. The rates of acceptance in the EU of trademark applications are higher than the rates in the US, and that just gives a sense that the trademark examiners are putting more scrutiny to this, and again, this is enabled by the system that was put in place. The Lanham Act protects unregistered marks on much the same grounds as registered marks, and that's sensible in many ways. Smaller businesses don't have the sophistication or expense to opt in, but they can get benefits from opting into registration. Instead, protection is tied to use in commerce. This has led to a split personality in trademark law, as my co-panelist Rebecca Tushnet has written about wonderfully. And as Margaret McKenna and I have written about, this is changing perhaps now because there are other incentives that are pushing smaller businesses to register their marks, so they can be on the Amazon brand registry as one very notable example, and so the law has to consider how to respond to that, but it does allow different pathways and for businesses to internalize the costs and benefits of going with registration or lack of registration, and I think that's generally a good thing. The Lanham Act didn't do this per se, but I think in the years after, the courts helped systematize distinctiveness through the case law. I think maybe it would have been better off protecting technical trademarks that rather than the broader set it protects now, and maybe Mark McKenna will speak about that in his remarks. But definitely, I think this crystallizes in the 1970s in the Abercrombie spectrum. And here, we see a range. Generic marks are not protectable, descriptive marks are protectable, not secondary meaning. Suggestive, arbitrary, and fanciful marks are inherently distinctive and immediately protectable. I criticize those frameworks and how they're understood, but I appreciate at a high level that they're trying to set out that when the semantic connection is too strong between a mark and the category of goods and services, that there shouldn't be protection, or there shouldn't easily be protection, because there's harm to competition in allowing one business to monopolize a term, Apple for your Apple company, or even a word that's too close to Apple for your Apple company, because competitors need that. And so even though I think some of the details could be changed here, at a high level, I think this is an important thing. And the last thing I'll just say is about consumer perception. So Christine Farley commented about this change being put into place. In my view, I think it elevates the consumer sometimes too strongly over promoting, over policing competition in other ways. But in my view, I think this is an important and helpful contribution, because I think it gives us a good vantage point through which to evaluate protectability and infringement. I compare and contrast to other areas of IP that sometimes don't provide either a vantage point or a vantage point that connects so well to the policy goals it's trying to effectuate. And this move to focus on the consumer is a change, and it's a change that helps connect to the goal of trying to keep consumers from getting confused in the marketplace and being responsive to how they behave. I will stop there, and thank you very much.
Okay, next up, Professor Merges will discuss patent.
Okay. I want to thank the organizers for having me down here, and thank so many of my colleagues from all over for coming. I guess the rest of the country being what it is, coming to Santa Clara in January seemed like a good idea. I agree. What I want to emphasize in terms of what went right is something that I think is often kind of buried in our consideration of IP. I'm going to mostly talk about patents, but I think some of what I say applies throughout. And that is the volume and velocity of transactions that are based on IP rights has grown amazingly since almost any point you want to pick in the past, starting in the 70s or 80s. I think it's a little bit invisible to us that IP enables so many different types of business models and transactions, and that's really what I want to focus on. How is it? And again, I'll start with the 70s. I'll go back that far, and I'll stick mostly to patent law. But how is it that the structure of the IP rights have, in this very quiet way, promoted so much transactional volume? And this goes back to my early days here. The first time I saw this university, I was on a bus headed for Intel. I was interning one summer, back in the days when Intel was all of, I think, 8 buildings further down in Santa Clara. My boss at the time, who's now a billionaire, said, buy some Intel stock and hold on. I did buy it, but then I had to sell it to go back to school. So I don't want to know what it would be worth. Do not tell me. But after that, some of my Intel friends founded a little software company, and after I had a gap year between undergrad and law school, I worked for that company. And that's when I really got interested in IP, because the trademark licensing, and in those days, you had to license different operating systems before we had essentially 2. There were a lot of licensing deals involved in any kind of software application that you might want to sell. And I sort of got interested in how the businesses were structured, in how we would license, right to use these different platforms. We had trademark fights. This was the first spreadsheet called VisiCalc, and we had VisiClones all over the place. And watching how that all worked really kind of fascinated me, how we could have a specialized software firm. A lot of the programmers had come from big integrated companies like IBM, where software wasn't a separate business. It was rolled into the mainframe business, and it was just like a kind of a service bureau for the hardware guys. And I got interested in how did software become an independent industry? You know, what made this possible for these specialists to split off and do their thing and integrate with so many different hardware platforms. So that story of, you know, business models and transactions is how I got into this field. So in some ways, I'm just coming around full circle. The things that have happened in the patent system since the Copyright Act of '76, that's what I want to focus on. First one, again, fairly hidden, was simply the recognition that where the IP rights reside can influence industry structure and transactions. That's not anything you're going to read on the face of the act I'm talking about, but that was the real purpose. And the act was the Bayh-Dole Act, right? The notion was we're not getting commercialization of federal technology because ownership is in the wrong hands. That realization as a part of the patent law was the first time, or one of the few times, that the Patent Act recognized that it's not just granting rights that matters, it's where those rights end up and what transactions they enable. So the whole Bayh-Dole revolution was just premised on the idea that we need to pay attention to the ownership structure, where rights begin and what transactions will flow from that and who will have an incentive to engage in them. You have to understand that that's in the shadow of a very restrictive set of doctrines that came along starting in the 30s and 40s that were really hostile to patent licensing. The Bayh-Dole Act was the first federal act, really, that stepped forward and said licensing can be good. Most of the case law coming to us from the Supreme Court from that era was quite hostile to licensing because some of the early licensing deals were blatant covers for cartels. That gave licensing a bad name. Things like patent pools and things like cross-licensing were looked at in a suspicious way. And the case law was fairly hostile both to the patent right and, of course, to transactions built on them. The big step forward conceptually was when the Antitrust Division of the Justice Department wrote some licensing guidelines whose bottom line message was we in the antitrust side will now hereby back off being hostile to patent licenses. What was left was the detritus of years of sort of anti-licensing doctrine, and we still live in the shadow of some of that. But the 95 licensing guidelines, I think, were really important because they said, if you're going to have restrictions on licensing, they're going to be from the patent side. We will start looking at licensing as just another contractual exchange, and unless we see the golden duo of market power and increased consumer prices, we won't bear down on licenses anymore. We kind of let it go. Rich Gilbert, my colleague in the econ department at Berkeley, had a big hand in those guidelines, and I know that's sort of how he saw things. The next step forward for patent law after the 70s was the development of doctrine that helped us clarify how patent claim interpretation was going to be handled. The volume of patents and the number of claims that one must navigate has increased very significantly since the 70s and 80s, right? And what the Federal Circuit did following the Markman case, which was mid-90s from the Supreme Court, what the Federal Circuit did was let's design a fairly mechanical claim interpretation process that will be formalist, that will be textualist, but will set forth a procedure about claim interpretation that can be duplicated and replicated in private transactions. And what that gave rise to, the whole emphasis on textualism and literal infringement, was the practice of claim charts. And I'm here to tell you that in terms of transactional efficiency, the simplification of claim interpretation and the narrowing of arguments over term meaning into a formalistic procedure, now we use claim charts, was a big step forward. Because dealing with the volume of patents that we have, and given the complexity of semantics, you could spin forever on claim interpretation unless you had a structure that guided the claim interpretation process into a fairly narrow channel. And I think that claim charts have been that sort of revolution. To me, the structure of the rights have important implications for transactions. So the literal infringement, which is based on strict liability, the claim interpretation, which is based on this fairly mechanical textualism, these things enable transactions given the very large number of claims and the very complexity of a lot of technical language. These are hidden, but what they've given rise to is a real boom in patent licensing. And what we see as the result, again, without much celebration, is things like we have the development of 3 effective vaccines in 2.5 years. If you look at the provenance of those vaccines, you'll see a long chain of licensing agreements because the inputs were developed all over the world by all kinds of research labs. What allowed those technologies to be integrated, what allowed a vaccine to reach the market, was in part a very high volume of transactions. A lot of patent licensing is behind the scenes when this technique is used to produce that vector, which is then used to produce this component of the vaccine. That's 3 or 4 licenses right there, right? So again, this is hidden transactional volume, but I think it's one of the things that really has gone right in the patent system. If you take that thought further and apply it to some other areas of IP, I think you can also see that transactional volume has grown pretty significantly in the other areas of IP law. Now, in entertainment law, transactions are specialized. They're essentially embedded in a complex set of institutions based in Hollywood and elsewhere. In trademark, the growth of branding, the idea of a business model of branding. Now, that's going to get, I think, some pushback from some of my fellow panelists. But from a transactional point of view, the ability to kind of create a celebrity endorsement business model or to promote it has really been a function of the transactional volume in trademark licensing. The other, I think, area that's very interesting that I've thought about a little bit is in the right of publicity, where eventually, sort of out of whole cloth, the courts propertized the right of publicity. And the reason they did so, I'm thinking of cases like the baseball card case, Halen Labs, the reason they did so was they understood there are things you can do with property rights that you can't do with straight contract. Contracting around a property right turns out to enable a whole bunch of transactions that can't be done any other way. And so when we think of IP rights, we often think of a sort of macro picture. What's the balance between incentives and access? What's the rights of the public versus the IP owners? But I think this transactional layer is a really important thing to think about. IP not only gives power to certain parties in economic transactions, but it enables a lot of transactions. And my colleague at Berkeley, Oliver Williamson, is well known for his theory of transaction costs. I want to focus on IP as transaction enabling. And I think that's a function of IP that has gone very right and continues to do so in many ways. So that's my 11 minutes worth.
All right, next up, Professor Tushman. Just pull it up.
Okay. All right. Except I've destroyed the tripod. Oh well. All right. I'll just talk into this. So I'm doing something a little different, unlike my predecessors. I'm not going to do an overview, but I'm going to talk about a specific provision of copyright law. And my thesis is this: just as democracy is the worst form of government, except for all of the others that have been tried, so too was Section 512, the safe harbor provisions for internet service providers, which has proven remarkably robust despite multiple efforts.
Rebecca, a little closer on the mic.
A little closer? Any better?
All
right. Is this working?
No.
Mine was just working.
Okay.
You keep the tripod going. You're good.
All right. Let's see. Is that working? All right. Sorry about that. Okay. So, I have my own litany of complaints about practical problems with 512. In terms of dispute management, though, it is a resounding success. I'm going to compare 512 to the recently enacted Take It Down Act and discuss the evolution of case law by comparison to Carol Rose's account of property titling systems. So what FiveTop does, in very broad terms, is it creates a safe harbor against monetary liability and sweeping injunctive relief that would require any changes in practices for online service providers that follow certain rules about how to handle complaints of infringement. It divides service providers into 4 categories, one of which is essentially defunct. Service providers that provide connections for content like email or private messaging or browsing the internet are supposed to have policies that terminate repeat infringers. That's definitely created some problems now. But for decades, the key provisions have been those for service providers who store content, like YouTube, or provide links to search engines or links in other ways, like Google, who won't be held liable for direct or secondary infringement if they promptly take down instances of infringement when properly notified about it. FiveTop explicitly says that service providers are not required to monitor their services for infringing content. It does provide for some liability without proper notice if a host or linker has red flag knowledge of infringement, but the courts have generally been pretty robust about making sure that that knowledge has to be specific rather than general knowledge that infringement is taking place on a platform, or even general knowledge that there are multiple copies of an infringing work on a platform. That isn't red flag knowledge. Unless the site is something like the top 50 movies to download right now, there's probably not red flag knowledge. So what went right with FiveTop? One way to measure it is how many disputes it's resolved. So in this case, it's a little bit of a follow-up to Rob's point, which is if you look at the case law versus the number of disputes, the number of disputes is in the multiple billions. Right? Even if a third of the notices sent to Google are invalid, which seems to be the case, largely because they point to locations that don't exist, it's still the case that there are billions of correctly targeted notices every year. There are some big FiveTop cases, right, litigations, but not that many of them. The case law tells you only what was significant to fight about in court for unusual reasons, either reasons of the defendant's deep pockets and structural significance in the entertainment ecosystem, or reasons of the plaintiff's very specific interest, usually a moral sense of offense. The everyday functioning of the system, though, is that lots of infringing stuff gets quickly taken down, often, if you believe Google, even before anyone has ever seen it. And uploaders who disagree with the takedown can file counter notices. A service that honors a counter notice is immune from liability for reinstating the content after a certain period, and the copyright owner has to sue the uploader. Very few counter notices are filed. So another way to measure success is that FiveTop immediately became the default rule around the world, certainly in practice. Even in Europe, with a fairly different legal system, FiveTop compliance was for a long time sufficient to avoid being sued successfully. This suggests FiveTop's utility as a workable compromise between the interests of IP owners and intermediaries and accused infringers. And you can also compare this to the fate of this roughly similar Section 230, which definitely spurred U.S. dominance in tech, but was not routinely accepted as the final word on intermediary liability in non-IP situations in other countries. So the DMCA just proved a much more popular model, in part because it seemed to actually to balance interests in ways that were more consistent with the non-U.S. view of sort of free speech interests. Europe eventually diverged, at least formally, by requiring intermediaries to engage in licensing attempts with copyright owners and screening of uploads. But I say formally because even today it doesn't seem to me that this has worked, except for music and popular video and big platforms. Major forms of copyrightable works like photographs and text are just not amenable to licensing requirements because ownership is not concentrated enough for comprehensive licensing regimes to form. European regulators have the benefit of not actually needing to require exact compliance with what looks like the plain meaning of the law. Being a good guy is generally enough in the EU, something that's often surprising to U.S. lawyers who expect a law that doesn't explicitly have a good faith standard to not have a good faith standard for compliance. So the result in this space is that the DMCA is still shaping behavior on the ground around the world. There was a major attempt in the last 10 years to gut the DMCA and put in concepts like notice and stay down in the U.S., which would require services to search for and remove similar copies after receiving notice about the location of one infringing copy. This is a brilliant branding move by by 512 haters. Stay down sounds almost like takedown, so how hard could it be? But it's actually a huge technical challenge, especially for smaller services, and it would have been a huge gift to YouTube, in particular, in maintaining its dominance. Fortunately, this attempt fizzled, which is one reason that sites like Wikipedia, Reddit, Ravelry, and the Archive of Our Own can operate in relative confidence without the resources of a Google or a Microsoft. Well, I do have some complaints. There's definitely complexity. We've already heard a little bit about Cox. We'll see what happens in the Cox case, and that will tell us a lot about what 512 means for connection providers in the US. The counter notice law is pretty genuinely a mess. When abusive notices are sent, it's very hard to hold the sender accountable. But I want to make the case that the crud accrued around various aspects of 512 is the standard fate of almost any law allocating rights no matter what. In her justly famous 1988 article, Crystals in Mud and Property Law, Carol Gross explained that all clear legal rules, particularly rules created by legislatures, face pressure from two sources: the ignorant and the conniving, the fools and the scoundrels. The ignorant don't know about the law, no matter how clear and crystalline it is, and they are subject to mistakes that make them forfeit rights, even though they didn't do anything morally wrong. They didn't know that land can only be transferred by writing, so they rely on oral agreements and hand over their money, and they're out of luck. The scoundrels exploit the clarity and hard edges of the legal rule to get unfair outcomes. The law says a mortgage has to be fully paid by a date certain, or the borrower defaults and loses land, so a conniving lender can hide out and make it impossible to find them until the time has passed, they get the land and lose the money. These abuses and unfairnesses pile up. Courts, for completely understandable reasons, make up special exceptions that allow equity back in, muddying the clarity of the written rule. Equity, of course, has its own costs. It makes disputes more unpredictable, therefore more expensive, disadvantaging poorer actors. Equity is also more reliant on the biases of the fact finder, who may have its own predispositions about the characteristics of good guys. I believe that much of the uncertainty accreted in the corners of 512 is the inevitable effect of Crystals in Mud as a dynamic. It's not unique to 512, therefore it's extremely unlikely that changes to 512 could do anything more than restart this process. Replacement rules suggested are either Mud all the way down, which I think is worse, or a different and probably worse Crystal that would not make either creators or intermediaries better off. So Rose concludes that when the mud gets too bad, the legislature generally intervenes to put a new crystalline rule in place. The fact that 512 has survived some reasonably well-resourced legislative assaults, to me, suggests that this isn't one of those situations where the mud has fully gummed up the works. I want to end by comparing 512 to the recently passed Take It Down Act, aimed at sexually explicit images indistinguishable from an authentic visual depiction published without the consent of the person shown in the picture. TIDA is not a safe harbor regime. Instead, it requires two things that aren't in 512 to avoid liability. Services have to remove accused images within 48 hours of receiving notice, with no clarity on what qualifies as receipt. I give it about 6 months before someone uses a mailing address and sues based on the time the mailed notice arrived at the building. Also, services must make reasonable efforts to remove known identical copies. There are no counter notice provisions, even if the content is fully protected by the First Amendment. There's no safe harbor against liability. There's no guidance as what counts as reasonable efforts to find identical copies, and what qualifies as knowledge. 512 does a lot better on all these counts. And I want to end with a warning. This is clearly a harbinger of attempts to do even more in proposals like Take It Down, which cover any use of a digitally altered license and provide for intermediary liability, even as the White House is posting AI-altered images on official accounts. Obviously, the political culture in the U.S. is partially responsible for this, but it's also a reminder of attempts to make law bite off more than it can chew are usually going to fail. Thank you.
Okay, Professor Dinwoodie.
Thank you, Brian, and thank you to Ed for the invitation. Ed asked me to address.
Oh, yes.
Yeah, thanks. Ed asked me to address international IP issues. It's a tough time to talk about international matters as the rule-based international order crumbles around us. So this is actually the poster. If I can get it, that's great. Just put it on one, Brian, if you can. That's the poster I have for my copyright class discussion this week. All right, and I could, if I was just focusing on international, develop that for you. But this is a positive path. All right. So, like Rebecca, I'm going to argue that a very particular thing that some federal courts have done right in the last 50 years is their willingness to accept jurisdiction were claims of foreign copyright infringement. So I'm going to first situate that assertion in the cosmology of international copyright law, as Barbara Rayner called it. And then I'm going to mention some of the reasons I like that liberalization of jurisdiction. And finally, I'll briefly float one reason why we're going to have to think more about that approach beyond copyright. So, first, as policymakers crafted the 1976 Act, they sought to change U.S. law in ways that ultimately would allow the U.S. to adhere to the Berne Convention. Of course, it took another 12 years before we got to that stage with the Berne Convention Implementation Act. But it was all designed to put the United States in a leadership position in international copyright law with a view to enabling more effective international enforcement. That in turn led to NAFTA and TRIPS at the multilateral level and aggressive bilateral efforts under trade law. Those initiatives on the public law side of international copyright law have not always been enthusiastically received outside the United States. One person's effective cross-border enforcement is another person's overreach and intrusion on the sovereign choices that other countries might want to make. But these moves on the public law side were used by private litigants to argue successfully that U.S. copyright law should not be applied extraterritorially based upon potential adverse effects on, say, the movie industry in the United States. For example, the Ninth Circuit in its en banc decision of civil films refused to contemplate the relief that was sought in that case, in part because it would disrupt the public international regime to which the political branches had already committed the United States. Now, to be sure, there are places where U.S. courts continue to offer relief without much regard for the interests of foreign sovereigns. The predicate act theory, under which foreign profits flowing from initial U.S. infringement can be secured in U.S. courts, often appears to be applied without regard to the law of the other country that's involved. But even there being recent assertion of the limits of that doctrine, most notably the Seventh Circuit in Motorola versus Ventura, albeit without some of the comedy-based analysis that I would have liked to see. So against that public backdrop, let me turn to the very specific positive development I want to highlight. There has been an historical reluctance, not just in the United States, but pretty much globally, to adjudicate claims of foreign copyright infringement. But the first recent effort to do so by U.S. support occurred just 8 years after the 76th Act in the London Film versus Continental case. The area district court judge in the Southern District of New York, Robert Carter, who was, before he was on the bench, succeeded Thurgood Marshall, the General Counsel of the AACP, permitted claims of a British plaintiff to proceed against a U.S. defendant for infringement of copyright in Peru, Ecuador, Costa Rica, Panama, Chile, and Venezuela, all of which I will note are sovereign countries. London Films wasn't a perfect opinion. For example, at one point the court labeled the South American claims as resting on the plaintiff's British copyright, which might suggest that Judge Carter was suffering from the same misunderstandings of international corporate law as the First Circuit indulged in 2 weeks ago in the Venner case. But his impulse to provide relief under multiple foreign copyright laws was, I think, spot on. He was motivated by the fact that New York was the only place where the defendant might be amenable to jurisdiction, and the explicit hope that the British courts would do the same if the shoe was on the other foot. And in fact, that transactional approach to international relations, where reciprocity begins to assume greater prominence, might well begin to influence any number of institutions in our Trumpian dystopia. For some time, London Film stood alone. Courts declined to hear foreign infringement claims, partly for the pragmatic reason of not getting into what they called the bramble bush of working out foreign law. That doesn't mean such cases were inevitably dismissed. Often the courts would simply apply U.S. law expansively to fill the enforcement gap. But eventually in 1998, Judge Carter's approach received appellate endorsement in Museumhaus versus Disney. In that case, the Second Circuit ordered the district court to hear consolidated claims under 18 different national copyright laws. Simply having to apply a foreign copyright law was not, the Second Circuit said, a sufficient reason to decline jurisdiction. Now, it's worth noting the reluctant trial judge never actually did try the case under 18 foreign copyright laws, because a global settlement between the parties, the terms of which were no doubt informed by the fact that effective full relief could have been secured from a U.S. court, soon materialized. And indeed, although there's not been a torrent of cases on this jurisdictional basis since Museumhaus, the availability of such relief has structured private behavior. This picks up a little bit of Rob's theme. And you see settlements. I saw myself this in a case in which I was involved for a small Chicago photographer who was able to secure compensation via a U.S. lawsuit for unauthorized uses in Japan when he would never have the resources to hire lawyers and bring a claim in Tokyo. The principle of adjudicating foreign copyright infringement claims was later endorsed in the ALI Principles on Transborder IP litigation and in parallel European countries, and has also been embraced by courts in Europe. Judge Carter was, as in so many ways, simply ahead of his time. Now, when the issue was being debated by the ALI Transborder Principles Project, some user groups complained this was simply a pro-plaintiff mechanism to maximize enforcement pressure. I think this is an unfair characterization of the rule. Sure, it will enable plaintiffs to secure relief when their resources might otherwise preclude such relief, but that's not a bad thing. This is especially valuable for small authors, such as my Chicago photographer, who lack the resources to litigate across continents. Large corporate owners can live to some extent with the old worldview rules and hire lawyers all over the place. Moreover, streamlining duplicative litigation is not inherently pro-copyright owner. I start my international copyright class with the case of Computer Associates versus Altai, which you probably know if you take a domestic course, having reshaped the infringement test in U.S. software cases. But Computer Associates didn't just sue Altai in New York. They also sued them in France for exactly the same works that were involved in the United States. After they won in the United States, Altai unsuccessfully sought an anti-suit injunction from the Second Circuit to restrain Computer Associates from relitigating exactly the same issue in France. This is just before Lucy Falls. But it would have been far more efficient for a small defendant to secure global clearance for legitimate competing software in a single case in New York. Now, as it happens, Altai won in France as well, but its victory would have been much cheaper and much quicker if consolidated litigation would have occurred. Moreover, this innovation in private international law rules is far more respectful of sovereignty and variations in national copyright policy than seeking to fill the enforcement gap with American law. It allows for the foreign dimension of a dispute to be adjudicated according to the foreign laws, rather than applying U.S. law to the entire dispute. Now, of course, while this enhances legitimacy and embraces the sovereignty of nations that's reflected in the principle of territoriality, it does create practical issues to apply foreign law. But convergence effected by public international copyright law, as we have seen over 50 years, has reduced the number of different copyright rules that might need to apply. There was no way there were 18 different rules at issue with Lucy Holmes. And the cost of the alternative, namely litigating the same dispute transnationally in multiple international courts, is not nothing. In short, this rule allows an internationally respectful way of providing transnational enforcement. Indeed, we might benefit from extending it further, subject to different constraints, even in the case of trademark and patent, where it has been seen as a no-go area. Let me just mention the patent side of that statement, because this is where things are beginning to stir. The distaste for adjudicating foreign patent claims in the U.S. courts was made clear by the Federal Circuit in 2007 in Voda versus Cordes, 1 year after the Court of Justice did exactly the same in the European Union in GATT versus Lund. Despite this, the ALI principles endorsed the possibility of adjudicating even patent or trademark claims, with only inter partes effect being given to a foreign judgment that held the patent invalid. But since 2006, the Court of Justice has walked back elements of its GATT decision. First in cases of provisional relief, Solvay and Honeywell, and just last year in the Electrolux case, in cases involving patents issued by non-EU countries. And in the last couple of months, a non-practicing entity, the UNESCO, has filed an action in Munich for infringement of a U.S. patent by BMW. This has provoked motions for anti-suit injunctions by BMW before Judge Albright in the Western District of Texas, someone who's very well informed about venue rules. And his initial instinct is to grant that type of injunction. And that is actually now going through the appeal process of the Federal Circuit. Well, this debate about exclusive jurisdiction is going to play out, probably, if I can go to the next slide, Brian, through anti-suit injunctions and partly through jurisdictional assertions of the Munich court, which we have yet to see. But I think there's going to be a dialogue between patent judges in different countries on that score. And that dialogue, I suspect, will be more productive and more respectful of sovereignty than the debates we are likely to see in the public international realm over the next couple of years. Thank you.
Okay, we have such an amazing panel who have really such expertise across the spectrum of IP. The first thing I'd like to do is give you all an opportunity, if you'd like to take it, to respond to the comments that were made by any of your co-panelists, to ask them a question, or riff on what they said anyway.
Sure. So I'm trying to put together a little bit of Genie and Rock, right? Which is about the increase in brand new transactions. And I want to connect that a little bit to Jeannie's consumer perception. So I think you're right that elevating consumer perception gives a particular character that would be useful in protecting consumer interest in some respects in current trademark law. But it may well be that the branding transactions that Rob talked about actually have manipulated, maybe too strong a term, but structured the consumer perceptions that actually is at the root of the expansion that you and others have criticized. I'm wondering whether you have any thoughts or reactions to what Rob was saying, or whether Rob had any reactions in response to the consumer perception.
I would say the following. Thank you. I was very struck when you talked about branding transactions, and those can be a blessing and a curse, as all these transactions, I guess, can be. And it does call to mind some of the worries. I think a number of people here, Mark Lemley, among them, have explored this in their work, that the way we structure these transactions can affect how consumers perceive things. Consumers are manipulable. And if we, I avoided this because I didn't want to be too critical as I was talking about what trademark law got right, and I think that's the worry. I mean, I think that, to me, that trademark law should take assessment of some of the normative goals, or at least backstop it wants to put in place about competition in general, to short circuit the ways that transactions can manipulate.
Any other thoughts or questions for co-panelists?
I'll add something to Rebecca here. You mentioned that platforms. You mentioned this in the context of Europe, that platforms are a little bit different, and so many of the copyright transactions that take place these days are mediated by platforms, and in many ways, I mean, some people are still using the DMCA for notice and takedown there, but I think about how there's licensing deals that have been struck that keep the user out of the equation in this context, and I'm wondering your reactions to that.
Yeah, so, especially as a global rule, that's pretty clearly worse, right? And thank you. And that's what I mean when I say, like, the existence of the DMCA. So I guess 10 years ago, copywriters started talking about the value gap, which I think has dropped out of the discourse now, but who knows? Which was that, YouTube isn't paying as much as Spotify because, if they decide to keep our music off, they can just keep our music off. Like, it's not central to their business. And that's, to me, that's sort of just competition. And the fact that YouTube has content other than music, and it's not, it's worth flagging here that, by the way, Spotify has then immediately tried to move off of its dependence on music by adding in podcasts and audiobooks, so that it too can pay less for the music, which is now less central to its business model. So I think it is pro-consumers who have alternatives to going through the platforms and cutting these deals, and Europe really shot itself in the foot in trying to encourage the development of European services, but also telling them that they would have to have comprehensive deals to actually start up. And of course, those comprehensive deals will be affected by the fact that music companies don't want to affect their deals with YouTube and Spotify, right? So one of the things that 512 has been good for is at least preserving the services that actually don't want to do that, or can't do that.
So I've got one just to follow up on that, or for Rebecca. So I have your observation about the fact that you just license out of digital single market directive in Europe is correct. Only in certain industries was that going to work. But of course, if you don't license, the other part of that equation is then you got to filter, right? You got to do.
Well, you got to do them both. Licensing does not remove the obligation to filter. Bizarre.
But if you can't license, your filtering obligations are under a different set of pathway. Those are my question to you on it. If you assume that stay down actually? Maybe I should actually this is a Perlin question. Is stay down better than takedown if it was technically feasible to do it?
No, right. So first of all, technically feasible is, technically feasible for YouTube and technically feasible for Ravelry are two very different things. Also, like the stay down assumes that the cost benefit analysis is the same for every service, right? So actually, I don't have real any strong intellectual property objections to YouTube having content ID and doing essentially stay down within YouTube. The problem comes when you say Ravelry, the knitting website, right? You need to have this whole apparatus, even though you get one DMCA notice a year, right? That's the cost benefit on that is ridiculous.
Well, but, I mean, didn't the EU deal with that with a series of exemptions?
So I think the answer is maybe, which is the point about crystals and mud, right? Ravelry is probably okay, but we don't know.
Well, a lot of them, and some of them are crystal-like exemptions in terms of, for example, turnover and number of customers and what have you. So I'm wondering what I'm moving towards is whether
Okay,
you're...
but that's not crystalline. So Eric Goldman has done excellent work on, it's actually not even possible. So Wikipedia, for example, is required to say how many visitors it has. They don't know because they're not set up to track that. They don't. It's not clear from the law. Like, do you count by device? If you don't count by device, how do you deal with people who aren't logged in? Because it's pretty clear that logged in users is not the right way to go. So actually, I work with the archive of our own. We do not know how many people use our services because we don't want to collect that information. Wikipedia doesn't want to collect that information. It's not important, and it's actually safer for our users if we're not tracking them. So that's the kind of assumption that when you do a rule that says, basically everybody has to do this, and to know whether you're covered, you have to, be able to prove you're outside this. That's just, it assumes the existence of a business model, right? It's regulation for Meta and Alphabet that just ends up damaging everybody else. And Wikipedia has decided we're just going to pretend we're a VLOC, right? We don't know. Because we think we can handle it, and Wikipedia is pretty much the only nonprofit that can.
Right, but I wonder whether that speaks more just to the, I'm going to go back to your point, that every time you articulate a rule, there will be people around the edges who there are uncertainties. It just seems to me that that speaks to the inadequacy maybe of the way they frame the exceptions. But the idea that you would actually have a variated set of exemptions based upon criteria such as turnover, size, units, etc., as a concept, when you end up with the big companies doing the stay down, is that inherently problematic?
I will point out, stay down, again, if you want to say our big companies doing stay down, they're doing it in the US, right? Yeah. Because for business reasons, it made sense for YouTube to cut these deals. We didn't need that. And frankly, you've imposed, think about how much money Wikipedia has spent, and it's a lot in the last, 5 years trying to comply with this stuff for no good reason, right? They're not, Wikipedia is not a vector for copyright infringement. It has, it gets five valid claims a month, right? For the being Wikipedia size, that's that's really low. So the project of saying we're gonna have this incredibly complicated system, and if you spend $500,000, you'll be okay this year, and then in 5 years you'll have to spend another $500,000. It's just not a good system.
Think about that.
Oh, sure, go ahead.
I've got a question for Rob. Rob, I feel your remarks were fantastic, and I was really struck by you focusing on the volume of velocity of transactions that have been enabled, and at the same time the mention of the Bayh-Dole Act in 2026. It's differently because it also seems to me, and this is even stepping a little bit beyond patent law, but things that flow into the patent system, is that whole system relied on the federal funding of university research that, since post-World War II, that then was allowed to flow into patenting. And so it strikes me, I wonder what you think about how to think about who is funding and should be funding some of the things that end up flowing into the patent system. I mean, we didn't used to have federal funding of basic scientific research or university research in earlier times. In fact, the framers thought it was prohibited. At least early Congress thought it was prohibited constitutionally. But I'm just wondering how you think about that in 2026.
Yeah. Well, I think that attitudes changed a lot when scientific and technological R&D became institutionalized and just grew in volume and complexity. My view is it's interesting that even probably at a moment when the libertarian view was probably most dominant. I don't know what you would call today, and I don't want to try, but it's not that. It was accepted and understood that some kind of research had to come from the federal government or from a centralized source. The only person who really resisted that, I think, was Milton Friedman. But that was one of his bad ideas that we didn't follow, fortunately. I think that the assumption that it was a steady state flow is built into Bayh-Dole, and I don't think that anybody has ever presented any empirical evidence that that system is a bad idea or doesn't work. Even when we had fairly protected monopolistic companies with R&D wings, I'm thinking of Bell Labs or IBM Research in their days of mainframe dominance, nobody really expected them to do the basic research that they sometimes did as an offshoot of their interests. So it's interesting because I think that the presumptions behind Bayh-Dole were so strong and in place that not even the most radical get government out of the way type thought that would ever change. So I think the two things that are different right now at this moment are there are people questioning that. People who benefited from the vaccine that's the product of 20, 30 countries centralized, federally, government-funded R&D are questioning whether it's a good idea. What do you say to that? I'm flummoxed. The other, I think aspect of Bayh-Dole that nobody anticipated was that it might be politicized. I think it sent a chill through everybody when the administration said, Harvard, we want you to account for all of your Bayh-Dole out licensing. Who does it go to? Are you complying with the domestic manufacturing requirement and all that? The system has worked because they have been mostly hands-off. And, from my political perspective, some of the arguments for march-in rights, for example, with respect to AIDS drugs, were not that far off base. But even then, it was resisted on the idea that this is a stable system with stable expectations. And I just don't think there's any theory behind this particular disruption that would lead anybody reasonable to say, oh, yes, this has been a failure, there's a lot of waste, et cetera. They used to give this, this sort of golden waste award, and they would pull some NIH grant that sounded silly, the health effects of lima beans every other day, or something that somebody at Idaho State was researching, and they would say, see how silly it all is. But then when you get things like, these people who were really focused on viruses and yeast and antibacterial viruses, and then we get CRISPR, that tends to shut that crowd up. Like, well, let's let the scientists do their thing. The point is that Eli Lilly's not going to fund yeast research. Genentech's not going to fund research. They didn't fund any of the Drosophila research that led to so much genetic insight. So what I have to say is it definitely isn't broken. And any attempt to sort of fix it, to me, would be wildly off base. And, I just, there are whole sectors of our field that no one ever contemplated could be or would be politicized. And I'll say in this group, and it stays right here, that as we know, many of us, it does require a foreign filing license to file a patent application overseas. And if any of these clowns ever get wind of that, they could really play havoc with the international IP system by either selectively denying foreign filing licenses and making some companies have to only exist with U.S. patents, or by corrupting it by saying, how much are you willing to pay for a foreign filing in China, Japan, and EU for an important invention? This is a potential disaster if it reaches the kind of people that seem to be looking for these kinds of opportunities. The whole system depends, and I thought, Graham, you might talk about this. The moment in history when Bern and Paris were created could hardly be more different. The discussions of a worldwide community of creative people, a worldwide community of scholars, the idea that we need to make IP rights seamless with respect to jurisdiction, the sort of final rejection of the mercantilist roots of much of IP law, Statute of Anne, the Venetian Patent Act, so on. We finally achieved that in the late 19th century. We're just trying to hold on. Because if these people ever politicize the international IP system, a whole bunch of structural things will just fall apart. And I don't know where that would lead. But I can say that system has been very, very good to the world. I really do. And it's simple. It's based on very simple premises. But think about the principle of national treatment with this crowd, the America First crowd. It's fundamentally a mismatch. If they ever go back to the roots of it and say, boy, this is based on a stuff we don't like, we are really in trouble. And so really keep it in this room that these opportunities are out there. You need to say to people in Washington, there's no way to change the international IP system. It's locked. Can't be touched. You can't do anything to it. I think that's our line until they go away.
Let me just ask one question before we open it up for questions from the audience. Maybe if we take a step back, are there any broader lessons that we can learn from the context in which these successes were developed? I mean, a broken clock is right twice a day, right? Someone who's blindfolded and throwing darts will eventually hit the bullseye. If we start with the premise that these successes were not just sort of randomly stumbled upon, is there anything about the successes that we've discussed today that give us a broader sense of when successes are likely to happen and what we can do to make policymakers and courts more likely to make the right decision rather than the wrong decision? Is it something about lobbying, right? There was something going on at the time that made lobbying weaker, or lobbies were opposed and they canceled each other out? Was it something about the composition of Congress and it was unusually partisan or bipartisan or focused on, pressing issues that were uniting people in other ways? Are there any characteristics about the things that you've talked about that give us broader pointers in the direction of how we can have more successes moving forward?
I mean, I'm happy to start because I think that some of the successes are not intended. And I think a lot of the things we're talking about are things that weren't necessarily intended. I think maybe with the 512 example accepted, to some degree, although I don't know that they envisioned things looking the way they did. And I actually think it's both a danger and promising, depending on how things are used, that there's a capaciousness in what the law does that gives the room to explore and adapt. And I think that's something that becomes apparent from, I think, everything we've talked about, that people use these tools in ways that were not foreseen by those who put them into place. And it's also scary sometimes when they're being used poorly, but I think that's a risk that's often worth living with. Because it gives the room to experiment. Now, I would say the thing I underscore in all that, there has to be the room to revisit. And I think some of the things that I get frustrated with, that even within the successes, are that someone put something in place, it worked, and things have changed, and we haven't reflected on whether it ought to be changed. I think, again, Rebecca's comments about the DMCA are interesting here, because yes, people did try to revisit it. It hasn't succeeded. But I'm glad they try to revisit it to some extent, right? Because it's worth interrogating.
Yeah, just one thing that struck me listening to this morning's and connecting it to us is how long it took for both the Copyright Act and the Lanham Act to get to the point where they were proceeding with the legislation. The DMCA was a little quicker, but even there was an extended process through the WIPO copyright treaty negotiation with the Europeans and what have you. And I think one of the one of the temptations, because the world we live in is so fast, that we've got to come up with solutions like that. Sometimes, especially when dealing with technology that's fast changing, a more contemplative approach, at least from the legislators, I think is something generally to be commended. The second thing I would say is, which gets back to Gene's point about the room for sort of innovation within the structure that Congress puts in place, and this picks a little bit on the thread we were talking about this morning, is you have to sort of, and Rebecca was talking about this in the trademark context, one of the things that bedevils that continuation is broader forces that are not IP specific, and in particular the move to textualism. The Lanham Act, a United States statement of the Lanham Act is a comprehensive textual treatment of trademark law. That's bullshit, but they included it. All right. The copyright law has a lot of stuff built in there for which it requires, given such a dynamic area of the law. And I worry that actually, we're almost regardless of what we debate as a matter of IP law, but the broader trends in judicial methodology actually put a lot of that at jeopardy.
Okay, with the time we have left, I'd like to open it for questions from the audience. So, Mark, I'll bring you the mic.
Thanks. This was all super useful. So these are for Rob. So I think you're right in general to say we've encouraged a lot of transactions, and that encouraging a lot of transactions is a good thing. But I guess I want to sort of push on a couple of points. Right. One is whether and to what extent property rights and particularly property rules are necessary to encourage those transactions. And my guess is we actually see a whole bunch of transactions that occur in the absence of these property rights, but they are not transparent, right? Precisely because there's no IP right, we don't necessarily learn about them. And as I've previously written, you absolutely see transactions in the wake of liability rules and other things, and rather than property rules. Second, and maybe broader question, and this is not just patents, but over across all of the disciplines, to what extent are those transactions productive? Right, and so here I'm thinking about, yes, we have a lot of patent licenses, some of which involve real technology transfer or business relationships that would not otherwise have existed, and that's a good thing. We also have a lot of patent licenses that are nuisance value litigation settlements, right, from patent trolls. My guess is if we look around, we see some similar number of things in the copyright and trademark space as well, and I guess I'm wondering whether there are useful ways to think about both in magnitude and in policy, how we distinguish them.
Yeah, so this is somewhat related to the point implicit in some of the comments from the panel here of the sort of one-way ratchet that IP rights tend to experience. I think first of all, I don't equate property rules, the possibility of getting an injunction. I don't equate that with the sole, that's not the driving force or the only force in all of these transactions. I think it is more complicated. Lots of liability regimes and possibilities can lead to agreement. But I think that simpler rules, of which, property rules sometimes fall into that category, they can promote transactions. Anyway, it's a longer conversation. The bigger question, I think, is dead on. I mean, we see a lot of rent-seeking agreements, which are basically agreements for somebody to get someone else with an IP claim to go away, right? It's a one-way transaction. We often think of those as ex post. The right's out there, somebody digs it up, they sue you for crossing their boundary line, which you had no idea, didn't know the boundary was there. And a lot of those settlements are not value-adding, really. I think the game, as I understand patent reform since roughly 2004, the game has been to try to limit the number of rent-seeking transactions. And the best way to do that, of course, is to tighten the patent quality to make the rights that we have worthy of transactions, right? I mean, basically, the game is not worth the candle if the rights are flimsy, weak, or in fact, basically fraudulent, right? And I think some of patent reform has been successful. The most important step in that direction has been the whole PTAB, inter partes review. Now that's subject to court-based, rent-seeking, lobbying, capture, you might say. And so those successes that we fought so hard for in the patent reform movement are now in doubt for various political economy reasons I won't go into. Yeah, the game is to make as many transactions value-adding as possible. And of course, the typical ones are ex ante when the technology is being developed. That's why I used vaccine development, because all the licensing enabled the creation of the vaccine. Backward looking, we dug up a patent and you crossed the boundary line transactions, which are really just legal settlements, are not something that I think are great. I know that trial lawyers and, I think your view on this, Mark, is based partly on the fact that you're in the trenches all the time and fighting off really dumb and bad patents and trying not to have to settle in a case where your client says, I never heard of these guys. Their technology is basically a word salad. They didn't contribute anything. Can you make them go away, Mark? The part of the world I'm more familiar with is the ex-ante world, you say biotech or startups, where two people really do want to cooperate and create a new technology, and ex-ante licensing makes sense. So the game has always been in patent law. You can go back as far as you want to sort of keep the rent-seeking, value-depleting part of it small enough so that the value-adding part can shine through and do its thing. I don't think that's changed. I think that's just the way it is. Every time you strengthen rights, you create an opportunity for more lawsuits. So restricting excessive litigation while strengthening rights is a real tough battle. In terms of the one-way ratchet point, I would say that it is the court's fault. So what I'm talking about is, people settle cases to make them go away. Then the courts interpret that as, this is now a common practice. This type of subject matter is often subject to a license, meaning a settlement. So the fact that private parties do it means we should incorporate it into the law. And so the more people settle things, right, the stronger rights get, reading from contract back to the property. We just have to police that. And we do in some areas, right? We don't always take the existence of a transaction as an indication that the law should shift to expand the subject matter of the property right. Sometimes we say, gee, it's too bad you signed those settlements. From this day forward, you won't have to anymore. I'll give you some examples. So licensing activity can add to the support that your invention is not obvious. But there are lots of cases where there's licensing and the court says it was still an obvious invention. I don't care about the license. You licensed rights to make the case go away. That doesn't mean those rights were valid. We could do that more often, right? We could say we don't have to we don't have to exclude something from fair use because people have settled some cases. We should always be aware of the fact that when we're being asked to size up the property right, transactions would be a good result, but they shouldn't necessarily be read off to mean the right must be expanded, right? The fact that people settle lawsuits doesn't mean the ever-expanding, subject matter of property rights. We should take that occasion to say, are these value-adding settlements, or is this just getting rid of a lawsuit that shouldn't have been there in the first place? I think we should do that more often, and I think it's lazy to say, well, it happens all the time, we'll just now expand the right. I think that's a lazy response. So I agree with the ratcheting up critique, and I think there has to be a limit, to how far a brand can go. Certainly, we finally settled on parity First Amendment as a limit. There should be others, based on your work and others. I'm sitting with great trademark theorists here. But my point is that you shouldn't always read off the existence of transactions and take that as a signal the right needs to be expanded. I agree with that critique. You have to remember that what you're trying to do is enable value-adding transactions. And you could expand rights infinitely and have 1 million settlements, and we'd be a lot worse off, right? But it also takes courage to say these transactions are not value-adding. And part of what's happened in the world of textualism, Graham, is a retreat to a safe harbor. I can't be criticized if I'm textualist. Can't be criticized if I'm originalist. Where's the courage? Where is the vision to say these transactions are no good, right? The concurrence in eBay is kind of the last time somebody said, wait a minute, what's going on? What's really going on? Hiding behind originalism and textualism is a form of cowardice in a lot of cases. And I think our judges, frankly, used to be a lot braver. Now, I know the reasons for that, appointments and all that. But look, it comes with the job. You've got to exercise your judgment. If you read Learned Hand's patent opinions, He was not shy at all about saying, boy, this is a piece of crap invention. Get out of here. He was not shy. He was also not shy about saying, this is really significant. What can we do to promote it and support it? Sometimes you just have to do that. I think we don't have enough of those voices today because everybody's scared, social media attack or whatever.
All right. As much as I would love to continue the conversation, we are now up against lunch. So please join me in thanking our panelists for coming.